Okay, we're going to open up the hearing for SB 518. On recess it. Yes. Yes, we are. My boss just told me that I have to limit the testimony to 3 minutes, so he's going to keep time of that. And with that, we're going to hear from Chris. That's the one. Welcome. Go this way. Yeah. Do you have any crimes?
Red is on.
Yeah.
So I spent almost 3 years studying and observing the asset condition problem, including an ISO and on the ground, and I'm confused by this bill. It appears to be an attempt by DOE and others to provide the illusion of regulation of asset condition projects while allowing Eversource to continue building its asset condition projects and charging them to ratepayers. I'm confused that DOE sponsored this bill, and I have 2 examples of DOE actions in the past with asset condition. Number 1, when I asked the PUC in 2023 to investigate Eversource's spending on asset condition projects in New Hampshire, the DOE, along with Eversource, claimed that the PUC did not have the authority to do this. The PUC said that it did, but it declined to investigate. So no money spent by Eversource on these so-called asset condition projects was refunded to ratepayers. Number 2, the DOE has granted river crossing applications for every asset condition project since it took over that job from the PUC in 2022. In no case has it decided that the asset condition project crossings are not necessary to meet the reasonable needs of service to the public, despite the complete absence of documentation by Eversource showing that any of the new lines were actually needed. The best way to recover the costs to ratepayers of Eversource's asset condition projects would be to get the PUC to investigate Eversource's more than 85 asset condition projects in New Hampshire for need, planning, and cost prudence. The best way to prevent asset condition problem in the future would be for the PUC to eliminate or substantially lower Eversource's guaranteed rate of return on investments. This bill's wording in IVA C3 states provides additional capacity or capability that benefits New Hampshire citizens. This would violate FERC's definition of an asset condition project, which can have only incremental, quotation, or incidental, quotation, increases in capacity. What is your definition of capability? Fiber optic is not permitted in the terms of most of the easements, a violation of landowner rights that hasn't bothered Eversource, the PUC, or the DOE. This bill suggests the following text about asset condition projects. Number 4, quote, has no alternatives that could provide a similar level of service to that proposed for a lower cost. Again, what if the level of service violates FERC's restrictions on increases in capacity in asset condition projects? This bill does not deal with the problem that Eversource pursues profits for its shareholders, which is best accomplished by replacing its infrastructure as soon as possible, collecting its guaranteed 11+% return on investment in new lines, rather than engaging in structure restoration, repair, and replacing structures only when necessary. Ratepayers are providing income for Eversource stockholders. Governor Ayotte has taken no action to stop this, and this bill will not stop this. Questions?
Are there questions from the committee? Thank you very much for your testimony. Catherine didn't want to speak. Catherine Court from the Sierra Club in opposition didn't want to speak. I got to be honest, I have no idea how to.
I think
Is that an art?
Cunningham.
Is there an art, Cunningham?
Nobody can read my writing?
No, are you a doctor?
No, I'm not a doctor.
All right,
I just play a doctor on TV.
yeah. That's where I recognize you from.
My name's Art Cunningham. I'm an attorney, practice out of Hopkinton. And I represent two clients here. One of whom is Chris Pastoriza, who just spoke, and her mother, who is Senator Ruth Ward. And I'm also representing the New Hampshire Sierra Club today. I think it's probably pretty obvious to the legislature now that this asset condition problem is a very, very big problem. We're talking billions, literally billions of dollars worth of projects that have been constructed or are on the planning board to be constructed by the utilities. What it's critical to understand is that these are regional projects. So the projects fall within FERC's jurisdiction and within the jurisdiction of ISO New England, the regional grid operator. The problem with the projects in terms of how they impact ratepayers is this. Nobody, no agency, ISO New England, nor FERC, have examined these projects for need. What's need? Well, do they need, these big projects need to be done at all? Are these existing right-of-ways or these existing structures in such a condition that they need to be replaced? For example, the X-178 is a $400 million project, start to finish. Nobody has examined these projects to determine whether or not there's demand, whether it's current demand or whether it's projected load. Nobody has examined these projects to determine whether the costs of these projects are prudent or are these projects gold-plated. Nobody has examined the prudency of the costs to ensure that the costs that hit ratepayers' bills are just and reasonable. Now, you understand how this works. When the project costs go in place, the bills for the costs for these projects get rolled automatically onto ratepayers' bills. It's what's known as a process of formula rates, which is a very opaque process. It's an automatic charge to the ratepayers with no examination of the cost whatsoever by any agency. So what I've done for my clients, both Chris Pastoriza, her mother, Senator Ward, is a couple things. I helped Chris in her PUC docket, which she mentioned. PUC declined to take the case. In fact, PUC has no jurisdiction over the case. We filed a federal lawsuit. The court declined the case because individuals are not permitted under the law, under the Federal Power Act, to bring such cases in federal court. So the last thing we did, we filed an action in FERC, challenged the cost. Now, I prepared exhibits. I brought exhibits with me, and I think I'm out of time. But if you look at the exhibits, if you look at the FERC filing, the FERC lawsuit, you'll see what we asked FERC to do, which is take a look at the project. Is it needed? Is it needed because of the condition? Is it needed because of demand? Are the costs prudent? And will it result in just and reasonable rates? I also brought with me, and I think you'll find it interesting, a letter that the Sierra Club, I wrote for the Sierra Club to the Department of Energy,
We're gonna have to wrap it up.
asking the similar material, it's asking the similar information. So I think the exhibits will be illustrative and useful to your understanding of the issue.
Are there any
Thank you, Mr.
questions?
Chairman.
Are there any questions from the committee? Seeing none, thank you very much. The reason we have a time limit is because they kick us out of this room at 12 o'clock because of another committee that has more priority than ours. So we just want to let everybody know it's not personal. So Campbell, you didn't say support, opposed, speaking or not speaking. Is there Campbell in the room? I'm assuming that's Campbell? Okay. Sarah Burke, no. Is there a Michael Okada in the room? So now I'm going to suspend my rule of 3 minutes because I had to interrupt him last time. So he will get 6 minutes.
I'll try to stick as close as I can for the 3 minutes. I appreciate that. Michael Okada, representing Eversource Energy, appreciate the opportunity to testify before you today in opposition to this bill. Just to start things off very basically, what is an asset condition project? And that's simply a project that is designed to fix an underlying condition issue with an existing line. So these are not new lines. These are not greenfield lines. We're not constructing a new line. This is an existing line where something is wrong with it. And I just point out these lines are essentially, they're wooden poles. They're, conductor. Many of them are off into very rural rights of way. Some of them run through the White Mountain National Forest. They've been there for many, many years. Some of them date back to the 1950s, the 1960s. They've been exposed to the elements, insects, rot, so forth. We inspect these lines every 2 years and more frequently as needed. And so as we do these inspections, when we discover defects in the lines, defects in the poles, rot, we prepare projects to address those issues, and those are known as asset condition projects. I would point out that, as was previously stated by the Department of Energy, transmission infrastructure, planning, and cost recovery are exclusively the jurisdiction of the federal government, FERC. The bill before you today, we view, would radically change and expand the responsibilities of the Site Evaluation Committee. And the DOE said, we're taking sort of a very different approach to siting. This is no longer looking at sort of a land use determination, but instead we're going to put in sort of financial and need-based criteria into our existing siting process. Our view is that this would result in significant delays, increased cost to customers, and ultimately a less reliable, less safe transmission system. By definition, these projects are designed to address an issue with the condition of the asset. And so if we have to have multi-year delays before we can go out and do this work, we will have a less safe, less reliable system. Last year, we had a red flag warning throughout the state. I was in contact with the state fire marshal at the time. We obviously have seen issues in other jurisdictions with electric infrastructure and wildfire damage. I would strongly encourage the committee to think about the potential ramifications of the decision of forcing delays. Also, just on a resource standpoint, the SEC has one employee. Right now, that position is vacant. Having all of these projects have to go through the SEC process would certainly exacerbate existing resource constraints. I know Senator Rosenwald picked up on that and asked some questions of the department earlier. That would also not just affect transmission projects, but any project that tries to move through the Site Evaluation Committee would experience these delays due to resource constraints. Just to tick through some of the specific issues with the bill. The bill would create two new classifications of projects: asset condition projects and qualified transmission asset replacement projects. The qualified transmission asset replacement project, and this was the 180-day deadline that Senator Waters had asked about at the last meeting, is essentially a project that could never exist. It is a project under its definition that does not require any permits. I am not aware of any project that does not require any environmental permitting, whether it's shoreland, waste, alteration of terrain, any project. If you're building a house, you're going to have permits. So the idea that you could have a transmission project that does not require a permit is simply not based in reality. So we view that as a bit of a red herring. That there's, this idea that there's a streamlined track. Well, the criteria to use that streamlined track is just not achievable. Moving on to some other specific issues that we have with the bill. The bill would automatically allow the Department of Energy and the Consumer Advocate to be full parties to SEC proceedings. We believe this creates duplicative and redundant efforts at the SEC. In fact, the Senate rejected legislation last year to make the Consumer Advocate a party to SEC proceedings. I just remind the committee there is a counsel for the public who is expressly there to serve as the public's representative. Under this bill, you would add both the Consumer Advocate and the Department of Energy, all representing the same interests. And interestingly, under current law, the SEC has to approve all the contractor and expert witness costs that the counsel for the public would utilize. This bill eliminates that oversight. So essentially, there's no oversight on expert testimony or consultant spending by these agencies, all at the cost of the applicant. And because, as you heard, these projects are FERC jurisdictional, all of that flows back to the customer. I'll just be brief with some final thoughts. You've heard a lot about concerns around transmission spending and that this is a runaway train and we're seeing spending go through the roof. I've shared two slides with the committee. One is from a FERC filing that transmission owners in ISO New England provided. And it actually adjusts, that's the one with the green line on it. It actually adjusts regional transmission spending investments for inflation. And as you can see, over the past several years, when adjusted for inflation, transmission spending has actually gone down. So obviously inflationary pressures matter a lot. These are capital intensive projects: the cost of steel, the cost of copper, the cost of wood, the cost of gasoline, contractors. I can go on and on. All of those create significant cost pressures. The second chart is actually from a Charles River Associates study that came out yesterday on United States trends in retail electric rates. And what you see is that exact same paradigm where yes, electric rates have gone up nationally, but it tracks almost identically to changes in inflation. So with that, I'll conclude my remarks. We hope that the committee will find this bill an expedient to legislate.
Questions from the committee? Senator Rosenwald.
Thank you, Mr. Chairman. Thanks for taking my question. So, and reading that a qualified transmission asset replacement project, it's on page 1, lines 6 through 14, basically is existing infrastructure that doesn't require any new permitting. It's maintenance, it's cutting back the trees around the wires. However, on page 2, line 4 and 5, wouldn't that require that routine maintenance to go before the site evaluation committee, which has already probably ruled on it unless the infrastructure was put there so long ago the SEC didn't exist?
That's a great question, Senator, whether routine maintenance would be captured under this. I will tell you, even for routine maintenance, we have permits with the Department of Environmental Services. So even, tree trimming that we conduct on our lines would be not under this qualified asset transmission replacement project. And I apologize, one final point I was remiss that I didn't make was there is review of these projects at the regional level. We make presentations to the Planning Advisory Committee of ISO New England. Sometimes we make multiple presentations. We present alternatives. We present our costs. We present the pole, the condition of the pole data. And that process has recently been strengthened in cooperation with NESCO, the New England Electric Council on States Electricity, to actually add an additional level of transparency where we have an independent reviewer at ISO New England that will be subjecting and reviewing all of these projects to do an evaluation. And the entire purpose of that is to allow parties to make challenges before FERC. If they decide that they don't believe that these are prudent investments, there is the opportunity to challenge these projects at FERC.
Follow?
And maybe I'm misunderstanding this.
Yep.
But let's say a squirrel somehow gets into one of your boxes. Would that require you to go before the SEC to get permission to do, I don't know, repair a hole that allowed the squirrel to get in?
Sure. So the threshold in the bill is a 5% replacement over 5 years, and there is no exemption for emergency work. So you could imagine a scenario where we're right up against that 5%. We've done work on the line. We've made replacements as required. And now we're right up against that. And we have an emergency situation where, a line is about to fail, a structure is about to fail. Woodpecker damage is a little bit more common than squirrel damage on the transmission system. This would require us to go through a multi-year process, spend millions of dollars in preparing an application in order to address that issue if we're right at that threshold.
Any further questions? Oh, Senator Barnes.
Thanks, Mr. Chairman. Actually, to return to some of the line of question I had last time, could you, we have the 180 days mentioned here, but then the intervention, the appeals, and so on and so forth. Could you imagine a process whereby there could be assurance that there would be a set time limit for review, and including repeals, filings, and so on and so forth?
So for a non-qualified transmission asset replacement project, so a normal project, really any project, again because of that permitting issue, the statute allows or requires a review of 365 days a year. However, the site evaluation committee can at any time essentially suspend that deadline, and they most frequently do if they determine it's in the public interest. So it's not a hard deadline. And I recall several years ago or a few years ago when the legislature was looking at making reforms to the site evaluation committee, which ultimately passed, there was conversation at that time of, would it be helpful to put a hard deadline in place? And the concern at the time was that essentially you could have opponents to a project just sort of run out the clock. And then if the record is incomplete at the end of the year, if that's a hard deadline, the SEC would have to deny the application because, opponents had essentially delayed and made it too difficult to move forward.
Follow?
Thank you, Mr. Chairman. Take another angle at this. Could you imagine a percentage that was larger than the 5% that would give you some confidence that you could get some fairly substantial work done without going through this process?
I think the threshold is only one issue. I think the underlying issue is that you have a fundamental and radical shift of the responsibilities of the site evaluation committee. Right now, it was envisioned as a one-stop shop for environmental land use permitting. And this would change that radically to be a review of project need, a review of these specific costs, which again are interstate transmission lines. And I would just note, there was a recent court decision in the PJM, Pennsylvania area, where it was actually a reliability project, which a reliability project is a new line to serve a reliability need, where PJM had essentially approved that line. The state siting council, on the purpose of need, denied it, and the state decision was overturned because these are, again, are FERC jurisdictional projects.
One last thing. Yeah. Thanks, Mr. Chairman. You mentioned ISO New England review of costs and so on and so forth. What opportunity is there for the DOE or other state agencies to intervene in that process at ISO?
Yeah, so it's a multi-step process where, and as I said, there are changes coming where we make presentations to the Planning Advisory Committee. All of those entities are members of that committee and have the opportunity, as does the general public, to participate, to ask questions, to request additional information. One of our projects that was mentioned earlier, we actually made 3 separate presentations, and each time we were responding to questions and requests for additional information, including the consideration of several different alternatives. The alternatives of, do you do it all at once? Do you do it in sections? Do you do it just on an as fail process? And we proposed to do it all at once because it was significantly more expensive. And again, we provided that information to those parties. The ISO is adding an additional step on top of that, where they will be engaging an independent reviewer who will be essentially reviewing all of these projects above a certain dollar amount and writing a report at the end with their findings and their recommendations. Now, the transmission owner can move forward with that project, but both through the PAC process and through this independent reviewer, if there are questions raised, if there are issues raised, then that is essentially building a record for those entities to make a challenge at FERC on the prudency of the project. And if a challenge is made at FERC, it's the transmission owner that bears the responsibility of showing that it was a prudent investment.
I don't think I may be heard correctly, but the parties that can intervene at the ISO New England and could appeal to FERC, does that include the state?
Yes, they are a
Okay,
part of
so
that
I thought
process.
I just wanted to clarify.
Yeah.
Thank you.
Senator Rosenbaum.
Thank you. I just want to go back to this need to go to the site evaluation committee. So the way I read this bill, there are 2 new definitions. One is a qualified transmission asset replacement project. And the second one is just transition asset replacement project. But the one that needs to go before the SEC is the qualified project, which needs no new permits, is not an expansion, doesn't require 5% replacement over a 5-year period. So it seems like it could be smaller projects. The way I read the drafting of this, that's what needs to go before the SEC, not the 5% over 5 years. Am I reading this wrong?
So our reading of it was both qualified transmission asset replacement projects and the transmission asset replacement project. Both of them have to go through the site evaluation committee process. The qualified transmission asset replacement project gets a bit of a fast track because it is supposed to be a smaller, less impactful project. The transmission asset replacement project goes through the entire normal course of an SEC proceeding, which is a year-long effort, at least year-long. That is our reading of it.
Senator Pearl?
Good morning, Mike. How are you? My head's spinning trying to understand all of this, and I'm not sure that I do. So if you make an application, currently you'd make the application to FERC for a project, is that?
So under the current process, we would inspect our lines as we do. And if we discovered that there needed to be a significant amount of work, could be replacement of several structures, could be replacement of an entire line. And when I say replacement, it is simply, replacing in kind. We're not, we're not expanding the right of way and so forth. Then we would make presentations to the ISO New England, the Planning Advisory Committee, and say, this is the project that we are proposing. This is the reason why. These are the costs. This is the timeline, etc. Those through those meetings, the different parties, including the Department of Energy, consumer advocates around the region, can push back. They can ask for more information. They can raise concerns. The transmission owner can move forward with that project, but they are doing so at great risk for a challenge at FERC. And if there's a challenge at FERC and they lose, it's significant investment that's at risk.
And so if you lose that challenge, essentially you can't pass that cost back onto the ratepayer.
Correct.
You can still do the project, but you just can't pass the cost back.
So at that point, the project would be constructed, and the parties would challenge the prudency of the project, and we are at risk for disallowance of whatever FERC found to be imprudent.
For cost recovery.
Correct.
Yeah. So if we add this extra layer, if I may continue, if we add this extra layer in, and the SEC says, no, you don't have the validation to do the project, or we don't believe it's a good project, but ISO says you can get cost recovery on it, how would that play out?
Yeah, so ISO isn't giving an affirmation, yes, you can move forward until after the project is completed. So this adds an additional step of state siting, but it changes the state siting process significantly, as opposed to, what are the land use impacts? What's the impact on wildlife? All the different things that the SEC has to find today. Now you're adding, quite frankly, a higher public interest standard in the bill than if we were to simply build a new line entirely. And I actually think Ms. Pastoriza pointed out some of the conflicts with the criteria in the bill, where there's a requirement that it has to increase capacity. What if it doesn't? If we're just rebuilding in kind. So this creates really both duplicative but also inconsistent criteria that the transmission owner has to achieve at a state level. And then, obviously there's the regional process that I discussed, and finally the FERC, the ability to challenge at FERC.
Do any other states have this type of process that you operate in?
So other states have more expanded roles of the site of their siting councils, but not to this extent, no.
Okay, thank you.
Senator Rosenwald?
I'd like to follow up on Senator Pearl's question about who's paying what. And I'm looking at the last section of the Bill 10, which sets up this fund, but it ultimately leaves taxpayers on the hook, because it says that if the fund doesn't raise enough money, the chair of the SEC can ask the fiscal committee for general funds. Do you read it that way?
So that is existing law. I think the only changes there were, you can see changing proceeding to proceedings. But there's been a structural challenge for resources at the site evaluation committee, and it really comes from two things. One, it's a fee-based funding source, as you heard previously. And that can be pretty lumpy, right? There are some years where there are lots of projects that get proposed. There are other years where very, very few, and we're actually in a period of very few projects being proposed. And so, trying to maintain a staff, again, we have one administrator right now, a vacant position, it creates a challenge. And so I think that was sort of a relief valve that the legislature had put in to say, hey, if there's essentially, if these fees aren't keeping up with the workload, there is an opportunity to get additional resources.
But we're expanding the work here
Yes.
and the draw on the fund with that same one vacant position, I'm presuming that we'd be seeing a request for more staff at the SEC. So
You got landfill bills coming up.
I guess my question is,
Yeah.
couldn't this lead to a bigger
You know,
draw
sure.
potentially on the general fund?
We view it that way, and I was surprised it did not have a fiscal note either.
Thank you.
Senator Waters?
Yeah, thank you, Mr. Chairman. I'll try to be quick. What would you think of a process whereby what you're going to bring to ISO New England would be subject to review and comment before you took it there?
So-
Very constrained review. Time
Yeah,
period.
I think the ISO process is exactly that. It is the opportunity for stakeholders to review and comment on projects. That is that in preparation for, if they so determine, a challenge at FERC. And there's been I would just say there has been significant effort cooperatively with NESCO, which the Department of Energy is a part of, to increase transparency and add additional layers of rigor to that regional process. And we think that is the appropriate jurisdiction.
Thank you. All right, thank you, Michael. Mr. Crease?
Thank you, Mr. Chairman. I'm Donald Crease, the consumer advocate, here in support of House Bill 518. I would like to talk about woodpeckers. So, a few years ago, we discovered that woodpeckers were pecking away at about 40 of the 400 poles that comprise the X178 line owned by Eversource that connects the COAS loop to the rest of the grid. So rather than replace those 40 poles, Eversource decided it wanted to replace all 400 of those poles and spend upwards of $400 million. Then we discovered two more things. One, no review for prudence anywhere, at any level, period, because of the formula rate process at FERC. So no review for prudence and no way of knowing whether this was a sound investment that should be recovered from ratepayers. And then we discovered that this is a huge and ballooning problem throughout New England. $5 billion of projects, so-called asset condition projects, replacing and upgrading existing transmission facilities that were really not going scrutinized anywhere. So then the Site Evaluation Committee was asked to take up the X178 project, and when it conducted its preliminary proceeding to determine whether it would take that case up on an elective basis, we, the Office of the Consumer Advocate, asked to be a party, and we got drop-kicked right out of the proceeding on the theory that because we care about ratepayer interests, which is really about rates, we had no interest in the SEC's proceeding. That was an incorrect application of existing law. The SEC is taking up the X178 project. We will again seek to intervene in that case, and if we are denied that time, we will take our argument to the New Hampshire Supreme Court. I'm very pleased that House Bill 518 carves out a party role for the Office of the Consumer Advocate. in SEC proceedings. And I guess I respectfully disagree with the claim that we represent the same interests that the Counsel for the Public does and that the department does. If you read the statutory charge of the Counsel for the Public, its job is to balance, I think, environmental interests against economic interests. The Department of Energy essentially represents the executive branch, which is the governor. I represent the only wallet in the room, the ratepayers, and we care about making sure that utilities make prudent investments. Now, you've heard some talk about the Planning Advisory Committee that exists at the regional level, but remember what the A stands for, advisory. It has no power. Here, as to state-regulated assets, our PUC scrutinizes Eversource's investments and that of other utilities for prudence. That's all we're asking for here. I've talked about this problem with federal regulators, FERC commissioners. They look to the states because the states have the authority around land use for transmission projects, they look to the states to rigorously scrutinize these projects. That's what Senate Bill 518 would provide more opportunities for the state to do. So I hope I've kept to something like my 3 minutes. Happy to answer any questions.
Seeing none, thank you very much.
Thank you.
Barry Needle?
My name is Barry Needleman. I'm an attorney at McLean Middleton. I've been there for 32 years, and for much of that time, I've practiced in front of the Site Evaluation Committee. I won't run through everything I've done there, but I'll note that in the last 15 years or so, there have been 5 transmission projects that have gone to the SEC, 3 Eversource projects, 1 National Grid project, and 1 combined Eversource National Grid project. And I represented the applicants in all of those. Based on my experience, I think there are significant problems with this from a very practical perspective, and that's what I'd like to talk about. First of all, I think it's critical to understand that it's very time-consuming and resource-intensive to prepare SEC applications. They typically take a year or more. They take a year or more to process at the SEC. Those timelines are frequently extended. In the application we just filed on the X-178 project, there are 17 witnesses in that. Many of those witnesses are non-company witnesses who are hired to provide reports that are only required in the SEC context. That is a tremendous expense. In addition, there's tremendous expense associated internally at the companies to prepare these applications. And so I think it's critical to understand that every time a project is required to go to the SEC, there is time and great expense associated with it. The second point I'd like to make is that I think it's very important for the legislature to understand that if there is a flood of new projects that head to the SEC, there is real doubt about the committee's ability to handle those. And I'm not just talking about asset condition projects, but I think that there are many people who hope that down the line we're going to see small modular reactors, maybe utility scale solar, potentially offshore wind. Those projects will get bogged down as well. And more staff is not going to fix the problem. And the reason for that is because the SEC now consists of 5 members, and 3 of those 5 members are the public utility commissioners, and they have to sit on every single docket. So you can give them plenty of staff, but they're not going to be able to manage the flood of projects. And I say that based on experience. In the 2015-2016 period, I had 4 simultaneous projects at the SEC. 3 of those were delayed beyond the statutory time period. The committee just couldn't handle the load, and that was at a time when the committee was bigger, when there were subcommittees, and when they had an experienced person in place in the administrator role. The last point I'll make is with respect to the expansion of interveners and the consumer advocate and so forth. A lot has been said about this. In my experience, Counsel for the Public has always done an excellent job of working to flesh out and protect the public interest and all aspects associated with that. In my view, adding more state actors to this process is just going to be duplicative and make it inefficient and much more expensive, especially given the lack of any required coordination. And I'll just I'll close by saying, in every docket I've had with Counsel for the Public, they've done a very good job of coordinating with us and the committee on who they're going to hire, managing budgets, and making it cost effective. And I think it would be very damaging to the process to remove that component. Thank you. Happy to answer any questions.
Thank you. So in our previous testimony, the big A word was brought up as advisory only, as far as, say, with the consumer advocate in this process. If we put this bill forward, does that change that?
I'm not sure I understand your question, Senator.
Meaning, will they have authority to stop a project rather than just advising against it?
You mean the consumer advocate? Yeah, essentially, this bill makes them a full party to the proceeding. So they have all the rights of a party, which is essentially a party in litigation, which would include hiring experts, cross-examining witnesses, and making arguments in opposition to the project, just like any other party.
Who pays for that?
When it comes to the hiring of experts and preparation of their external reports, it would be the applicants that would pay for it.
Questions from the committee? Thank you very much for your time.
Thank you.
Josh Elliott. Department of Energy? Thank you for
You'd be
coming.
correct, Mr. Chairman. Again, for the record, Josh Elliott, Director of the Division of Policy and Programs for the Department of Energy. I have with me Mr. Dan Phelan, who is our Wholesale Policy Administrator.
Hey, so thank you for having me again. I'm going to try to be quick to be respectful of the folks who are here for a lot of important things today. But there are some things that I do need to clarify. So I want to talk a little bit about what the review process that exists today is and what it isn't. And I got to correct a misstatement that was made earlier. So as Mr. Crease indicated, things are brought before the Planning Advisory Committee. I do not want you to get the impression that that is ISO New England. The Planning Advisory Committee is a group of stakeholders that weigh in on a project, but do not have the ultimate power to stop a project from going forward. They undergo technical review, and so other transmission owners can say, hey, I don't think that quite looks right. Maybe you want to reconsider doing it a different way, but it is advisory. Again, it is not an independent review by an independent entity. ISO New England is setting up a process for review of these projects, and hopefully my friend from the ISO doesn't need to correct anything that I need to say, that I say right here. But that is a long road. It is a process that there's an interim process being set up. The final process is more than a year away at this point. And as I indicated in testimony last week, there are a lot of projects that are moving forward during that time. And then the final thing, and I think the most important thing, was a statement made about the utilities having to prove, the transmission owners having to prove that the project is prudent. They do not. The burden of proof is on the challenger to prove that the project was imprudent under FERC law. Federal Power Act is very complicated. We could spend a whole semester talking about it, but that is the case today. That is how the formula rate process works, and the state's stakeholders, ratepayers, do not have the ability, a clear path to proving that a project is imprudent. That was the important thing, the really important thing that I wanted to impress upon you. Glad to take questions.
Questions from the committee? Come on, give me one. Senator Rosenwald.
Thank you. Is this a bill directed at one project, the X178?
No, so I think that was sort of the moment where the collective stakeholder community, where our eyes exploded. That was a particularly egregious project as presented initially. There are a number of other projects that have gone through the Planning Advisory Committee over the past years. It's that one again, Mr. Crease indicated that it was 7.5% of the poles had structural damage. Eversource proposed to replace the whole line in order to add something called optical ground wire, which is not related to the underlying condition of the assets. We've had further developments on that project. More recent inspection data has been provided by Eversource, but this is not specifically about X178.
Thank you.
Seeing no further questions?
I will be very brief. You have a policy question before you. Do you want the state to have a mechanism to control these costs and ask transmission owners to, when they're going through these projects, to say, yes, they're prudent, yes, they need to be done, yes, it's in the best interest that these projects get done, and are they done in such a way that is cost effective or not?
Thank you, Joshua. Nate?
Thank you. Nate Grace, Business and Industry Association, the statewide Chamber of Commerce. We oppose this legislation. Our concern here is really at the core that the delay of replacing or repairing existing assets, existing transmission and other lines, that delay would result in two things occurring. First, that it would result in higher energy costs because of the added layers of kind of governmental regulation that have to be gone through. And the second is that it would potentially result in additional outages because, of course, we're not replacing assets that we've agreed at least a portion of them need to be replaced. And they're now having to go through this potentially year or longer process. Obviously, any sort of outage results in a loss to the New Hampshire economy, and we believe that the utilities have done a pretty good job over the past couple of decades doing repairs in advance, looking at their assets. I don't have the numbers off the top of my head, but I know Mr. Licata does, about comparisons of how long it took them to restore power for various weather events over the years. Obviously, you know, one of the things that we're repairing lines for is damage from weather. So we'd like to be able to repair those as fast as possible and get the economy going again. Happy to take any questions you may have.
Questions from the committee? Seeing none, thank you very much, Nate.
Thank you.
We do have a representative from the PUC here. If you want to have any questions from the committee, or did you want to speak? Okay.
Good morning, Chair Avard, Vice Chair Pearl, Ranking Member Waters, Senators. My name is Mark Delafano. I'm a PUC Commissioner and the current interim chair, which also makes me the current interim chair of the Site Evaluation Committee. I'm here today to talk about this bill as it relates to my current role as being responsible for implementing the will of the legislature via the Site Evaluation Committee. Few things that I just want to point out, and we're not taking a position either way on this bill. Quite frankly, this is the legislature's purview, and we will put in place whatever the legislature enacts. I do have a few things I wanted to make sure that you thought about while going through this. Firstly, there's been a statement by some of the witnesses that there's one employee at the SEC. There are, in fact, 0 employees at the SEC, and there are 0 positions at the SEC.
That's helpful.
The SEC administrator is a PUC employee, and that employee does and will have, because the position is currently vacant, duties at the PUC as well as at the SEC. And so this person, I hope to eventually put into this role, or perhaps my successor will put into this role. I'm looking for someone who can easily implement the different kinds of things that need to be done at the SEC and the PUC to move these processes along a little bit quicker. The second thing I wanted to kind of point out is regarding the timelines for the qualified asset condition or asset replacement projects. In my opinion, the timelines are a bit aggressive, given our staffing and the other demands on the PUC's resources. That was brought up in the first part of this proceeding last week, that I think it was Senator Waters and perhaps yourself, Senator Avar, that asked if the SEC would be able to meet the deadlines for those tight deadlines for the qualified replacement project. And I'm telling you that given our current staffing, that would be very, very difficult and probably not likely. The third thing I wanted to point out is that the SEC is currently set up as a siting board. And so, you've heard a lot of things about FERC and federal law here today. The siting of energy transmission projects, electrical transmission projects in particular, is the venue of the states. So the individual states get to deal with the siting aspect of it, but things that have to deal with the economic benefits or the rate impacts, those kinds of questions are really FERC questions. They're not really questions that a siting council is set up to really address. And so, if this bill in its current form went into law, of course, we would implement whatever we're told, but I would personally be concerned about facing a federal lawsuit if a project certificate was denied based on some benefit to New Hampshire ratepayers not being met. There are probably different ways the committee could work with the language, working with the stakeholders to come up with something that would make some sense. But just the way I read the current version of the bill, I think that there's a true litigation risk there. And that increases the regulatory risk here in New Hampshire. And so regulatory risk is something that doesn't get talked about an awful lot. But as the state's statutory scheme around utility regulation changes, that creates regulatory risk, especially when we put in place schemes that are kind of untested, and in states that have tried this, like Pennsylvania, very recently, that case was overturned by a federal district court, and that district court decision was affirmed by the Third Circuit in September of 2025. That's Transource v. DeFrank. So I would just be very leery of asking us to implement something around rates or rate decisions, given that that's FERC's responsibility. And then finally, I would like to also point out that presently there are two state agencies that are involved with the SEC process. It's the SEC/PUC. Okay, we'll just say that's one agency just for the time being, but it's technically two. And the Department of Justice. So the Department of Justice, through the Counsel for the Public, rigorously defends the interests of the public at SEC proceedings. This bill would add both the Department of Energy and the Consumer Advocate as automatic parties to these matters. It sounds like a lot of government to me, folks. So just something to think about. I'll take any questions.
I think you got one.
And I cannot speak about any specific projects. Just want to please reiterate that.
Senator Waters?
Thank you, Mr. Chairman. So I can't tell you about the woodpeckers and squirrels on Maple Street. Okay, that's good.
I have to go like this.
Anyways, really to that last point is what I wanted to discuss about the role of the consumer advocate, because wouldn't it be fair to say that despite the Department of Justice there, that they really have no long-standing expertise in rate making and in consumer protection in this area?
There's no doubt that the consumer advocate has extensive experience in that regard. And as someone who he appears before regularly, he does an admirable, if not excellent job representing the interests of his constituents, residential ratepayers. That all said, this is a siting board, the SEC, Senator, and it would be concerning to me if we were having rate arguments at a siting board, especially where rates are not something that the SEC should be passing on.
I may follow up on that. Aside from saying I was rather perplexed by the fact that the consumer advocate was not allowed to intervene previously, it does seem to me that, and I worked a lot with Chairman Bowes on creating this SEC process, that it was very clear that we were concerned about costs and the length of time it took to review things, because that was directly related to the cost of projects with inflation and whatsoever. So that it's kind of a question though, is that can you really imagine that citing has no impact on, and decisions about it would not have an impact on costs?
Well, I think if we're talking about the costs of the project, then, that's one thing. But if we're talking about rates, that's something different. So I would agree with you, and I think the Seabrook Nuclear Power Plant is a perfect example of a time where, certain costs were identified, and as the process unfolded, those costs multiplied by almost an order of magnitude.
Bankruptcy.
And resulting in the eventual bankruptcy of Public Service Company of New Hampshire. But again, I'm not really here to, tell you folks whether or not I or the SEC or the PUC believes that costs aren't an important aspect of this kind of a bill. I think what I'm here to talk about is just what it would take for us to administer this and, create the process and enforce the process at the SEC based on the statute or the bill as currently written.
Thank you, Chairman.
Any further questions? Seeing none, thank you very much.
Thank you,
I
folks.
have nobody else to speak on this, so we're going to close the hearing. And give me 2 seconds here. I wasn't planning on doing that today. So we're gonna take our time. Can you hand that to him?
Oh,
Yeah.
no, this is the new one.
Oh, this is the new one?
Yes, he switched to the new way over.
Okay, so I'm not gonna limit him to time, 3 minutes, because I'm not gonna. Yeah.
Everybody else.
I can't be professional. I gotta go use the restroom. So we're gonna open up the hearing to SB 536 and hear from the prime sponsor.
Thank you, Mr. Chairman, members of the committee. For the record, my name is David Rochefort, Senator from Senate District 1. I'm here to introduce my bill, Senate Bill 536, relative to Solid Waste Facility Site Evaluation Committee. If this wasn't such an important issue, I probably would open up my testimony with a rendition of I Got You, Babe. Because I know many of us feel like this is an issue that keeps coming back over and over and over again. And in the last 6 years, I think that we as the legislature, not just our body, but the other body, has come to recognize that solid waste and the disposal of solid waste isn't just a state issue. It isn't just a local issue. It isn't just a regional issue, but it's all of the above. So Senate Bill 536, which none of the concepts here are anything that you all haven't heard. We've been talking about them for a long time. But it attempts to find some balance with all of those. I know you're going to be hearing from some people after me that really could probably produce volumes of articles written on how important an outcome of this is, and it's been documented in the media, not just New Hampshire, but certainly regionally and also nationally. What 536 does, it sets up a site evaluation committee for siting new landfills. It will, in that site evaluation committee, it will take feedback and input from the state, from local entities, from regional entities, where it's all going to be affected. The site evaluation committee will consist of 7 members from a variety of experiences, and they will be taking into account a number of factors that go into siting these facilities, and understanding the fact that we do need a place to put our trash, but because there are so many pressure points, it's important that we get feedback for all of that, and that's what the site evaluation committee will do. It will again also underscore the importance of brownfield sites versus greenfield sites. Where do we have brownfield sites currently that we could place some of these things, as opposed to siting them on greenfield sites? So I know that you've had a long previous hearing. I want to keep my comments brief, and I'd be open for any questions that you might have.
Questions from the committee? Seeing none. Thank you.
Thank you very much.
Catherine, from the Sierra Club? Catherine N. Corky? Corker, is Kathy here?
She must have left, she was here.
Okay. Mr. Tom Tower? Be right back. Okay.
Good morning, welcome.
Good morning. Well, good morning, I guess, Deputy Chair. Good morning to the members of the committee. For the record, my name is Tom Tower, and I am a resident of Whitefield, New Hampshire. And I am also representing North Country Alliance for Balanced Change here in support of Senate Bill 536. I want to thank Senator Rochford for his leadership on this issue. And let me first begin, and I'll try to be brief here, that this issue has been going on for a long time. It's been divisive and difficult in recent years, and prior efforts have created tension between communities, agencies, and the legislature. And I'd like to liken back to some of the comments that Senator Waters made in front of the full Senate body, and certainly has made during committee, that this whole issue has been a long, very arduous, very difficult issue for all of us, and that we really do want to put this issue behind us. And we believe that Senate Bill 536 is different. It's designed to be workable. It's ideally supported by DES, and hopefully we'll get an opportunity to hear from them, and that we're confident the vast majority of the legislature, as well as the governor's office, would support this concept of establishing a site evaluation committee. I think we know that the governor is on record as recommending the creation of a site evaluation committee for solid waste, so that we are confident that if something like this were to reach her desk, that she would support it as well. This bill is a reset, if you will. It's not a continuation of past conflicts. So why is 536 so important? Large solid waste facilities affect more than what's captured in current DES permitting today. largely technical in nature. What doesn't get taken into consideration are impacts like noise and odor, traffic, tourism, property values, and long-term economic health are often felt most at the local and the regional level. These impacts are real experiences, significant experiences for host and neighboring communities, and they deserve structured consideration. These communities are taking the brunt of these impacts, and it's important, I think, that they have a voice in the process. What Senate Bill 536 doesn't do, it doesn't weaken or override what DES does today. It complements DES by the creation of a site evaluation committee focused on the broader public interest. It's a combination of environmental compliance plus community impact, an added lens, if you will, on what definitely has generational impacts. So why does the process matter? 536 creates a clear, transparent, and predictable framework. Applicants know the expectations up front. Everybody knows the rules of the game. Municipalities have a defined and meaningful opportunities to engage. The public gains confidence that decisions are made on a full and balanced level. Folks, good process builds trust. And when decisions have multi-generational long-term impacts, that type of trust is important when you're going to make these type of long-term decisions. So some of the ingredients that build trust is the creation of an intentionally balanced site evaluation committee. It includes state leadership and municipal and regional planning experience and members of the public. Strong conflict of interest standards help ensure credibility and independence. Decisions are informed, fair, and insulated from undue influence. Now, a couple of things here that the bill does and what it doesn't do. The bill expresses a state preference for expanding existing permitted landfills or redeveloping brownfield states. And after what we've talked about for the last 5 to 7 years, it makes sense to be choosing brownfields versus greenfields. However, the bill does not force any community to expand a landfill. And you're going to hear an awful lot more about local control in subsequent testimony here this morning. It does not exempt large expansions from review. It does not ban new facilities outright. The preference is real, but it respects local control. It respects local control. 536 doesn't say yes or no to any specific project. It says that decisions about large-scale local waste facilities should be deliberate, open, and based on a full understanding of benefits and consequences at every level. This is reasonable, it's responsible, and an overdue step in the process. The bill improves how decisions are made, not what decisions must be. And I'll repeat that. The bill improves how decisions are made, but not what decisions must be. So with that, let me thank again the committee for your time this morning, and I respectfully urge all of you to support Senate Bill 536, vote it ought to pass, and I am happy to take any questions you may have.
Questions from the committee?
Thank
All at once now. All right, thank you very much. Catherine McQuarrie? McQuarrie? No timer on this. We got plenty of time.
Hello, thank you. My name's Catherine Corkery. I am the chapter director for New Hampshire Sierra Club. We have about 15,000 people in the state who are members and supporters, and we support this bill. I feel as though there's been many years trying to resolve this problem of of this landfill, and landfills in the state. And I support the idea of having a fair democratic decision-making, including the communities impacted, as well as the applicant, as well as the town officials, and state agencies. And what better place than the Site Evaluation Committee? This is a little different than energy issues, but it is a land-focused, community decision-making process that we need. And I ask that this committee take it upon them, upon yourselves, with wisdom and the need to resolve this problem. And I ask you to pass this bill. I know there's another bill, and following this one, and they're really different. So you have a really big issue in front of you, and I really ask that you come with the mindset of resolving this issue. I feel as though there's a lot of ends and no together. There's no collaboration. And I ask that you do that. I know it's hard, but we will support you in finding that collaboration to resolve this problem. Thank you.
Thank you for your testimony. Questions from the committee? Seeing none. Rich Southwell?
Good morning. My name's Rich Southwell. I'm a Bethlehem, New Hampshire resident. Lived there with my family since 2023. I support this bill very strongly. It recognizes that the solid waste industry has taken many shifts, many turns. It's expanded in complexity and the degree of risk inherent in that business. And so this bill brings in a variety of relevant disciplines to try and get to the very best decision for all involved. As I went through, and this is going to be a shameless plug for my profession, as I went through this bill and looked at the various disciplines that are represented, the one thing that I found missing was an actuary and/or insurance expert. And the reason that that is important, as I said, is that this business has become far more risky than it was 100 years ago. 150 years ago in Bethlehem, New Hampshire, we had these big, beautiful inns. It was a playground for the rich. They would come up in the summertime. And as you hike through the hills of Bethlehem, you will occasionally come across an old dump site, 100 years old. They would go out in the woods, dirty dishes, broken dishes rather, china, bottles, cans. That's all they had to dump. All biodegradable. Metal cans were obviously made long before they started lining those cans with plastic. Now we've got PFAS, we've got electrical components. All of those things are getting dumped in a giant hole with a liner that we hope works and will be effective to contain those elements. And we are entrusting responsibility to solid waste operators. One of those is a publicly traded company that operates in Bethlehem. We'll talk about them a little bit later. But they put out, because they're publicly traded, 10K annual report to shareholders. Item 2 in that very voluminous report is called risk factors. And this is where they have to disclose everything that could possibly go wrong in their business that would impact the value of their investors or their shareholders' investment. I want to read one of those sections. This is from 2024. It was released in February of 2025, so they were recounting 2024 results. 2025 results should be out in a couple of weeks. But in the risk section, 1A, risk factors, our insurance coverage and self-insurance reserves may be inadequate to cover all significant risk exposures. It goes on. The provision of resource management services, including the operation of landfills, a substantial fleet of trucks, and other waste-related assets involves risks. These risks include, among others, the risk of truck accidents, equipment defects, malfunctions and failures, improper use of dangerous equipment, the release of hazardous substances, fire and explosion, any of which could result in environmental liability, personal injury, loss of life, business interruption, or property damage or destruction. We carry a range of insurance policies intended to protect our assets and operations, including general liability, property damage, and environmental risk insurance. While we endeavor to purchase insurance coverage appropriate to our risk assessment and seek to minimize our exposure to these risks through maintenance, training, and compliance programs, we are unable to predict with certainty the frequency, nature, or magnitude of claims, direct or consequential damages, and as a result, our insurance program may not fully cover us for losses which we may incur. It goes on from there, but you get the general idea. So they're entrusted with a very high-risk endeavor. They think they have enough insurance. I can guarantee you, as an actuary, that they've got very high risk retention, so they're on the hook for the first many dollars. Haven't seen their program. And I know that the insurance market for environmental liability and pollution coverage ebbs and flows, and sometimes coverage simply isn't available. And so the one critique that I have of this bill is we absolutely, as a state, wherever these sites go, have to do a very focused job of monitoring the insurance programs and the parent company's wherewithal to pay should the worst occur. I'll take any questions. Thank you.
Questions from the committee? Seeing none, thank you very much.
Thank you. Back in a bit.
So we have Nate again.
Thank you, Mr. Chair, members of the committee. Nate Grace for the BIA, the Statewide Chamber of Commerce. We oppose this legislation. New Hampshire already faces tightening disposal capacity, and one of the things we're very concerned about is, what happens when we have decreased capacity, what happens when we are required to send more waste out of state. And from what we've heard from our membership and from people who work in the solid waste industry is basically disposal costs are going to increase, and those costs are going to be passed on to companies and to individuals who need to dispose of waste. And so we understand there are a number of issues that are trying to be addressed in this legislation, but our position is that DES already offers a comprehensive and rigorous environmental safeguards throughout the landfill permitting process. And adding this additional layer of complexity, adding these additional reviews and regulations that include everything from, sort of subjective assessments of, what might happen with tourists if there's, an expansion of a landfill or a new landfill here. That's going to add additional time on the time it takes to either expand landfills or create new landfills and deal with the solid waste issue. That will ultimately boil down to this committee that's being formed making a decision on the net public benefit as compared to any adverse impacts. And we just don't see how that results in an objective decision based on the language of the bill. We think that would end up being a subjective decision based on realistically who is appointed to that committee. Happy to take any questions that the committee may have.
Questions from the committee? Senator Rosenwald.
Thank you, Mr. Chairman. I'm interested in your statement that it will mean more cost to transport waste out of state. But hasn't DES testified that we are not going to run out of landfill capacity until at least 2037?
Yes, that's true. But as we've looked at, I know DES is here and will testify, so they can probably provide more insight. My understanding is that it's not necessarily that we're going to run out of landfill capacity, but as we sort of go towards that timeline, the operators of those facilities are going to be looking at alternative answers. What happens if we don't get the expansion and we can't take those materials, or the materials markets change as we saw when China and other countries in Asia stopped taking recycling and we had to start landfilling some of those products. So it's really a supply and demand issue where we're looking at not only the capacity for landfills, but also the market and how materials are flowing through that market. We've seen other states like Maine regulate sludge and other materials because they contain chemicals that the state of Maine has determined that they want to regulate. And a lot of those materials are being landfilled, and that's affecting capacity as well. So this is an ongoing and complex conversation, is my understanding, but I'm sure DES can provide more insight.
Thank you.
I have a question. Mitch, how long have we been talking about this issue? How many years?
Well, I had a different job that I started in 2019, and I believe one of the first hearings I came to was on solid waste, and we haven't solved the problem yet.
Right, so we're looking at 2037.
Mhm.
We had the green light today. How long does it take to make a landfill? Or I mean, I could probably ask DES on that, but.
I wouldn't be the person to be able to answer that question, Senator. I can certainly find an answer and
But
get
it's
back
about
to you.
6 years, maybe 7. Have we been talking about this?
I
Maybe
think
a little
so.
longer. All right, no further questions. Thank you very much, Nate.
Thank you.
Appreciate that. Yeah, I want to make sure I get everybody here. Mark? Welcome back.
Thank you, Senator. Good morning, Chair Abard, Ranking Member Waters, Senators. My name is Mark Delafano. I am a PUC Commissioner and the PUC's current interim chair, which makes me the ex officio chair of the Site Evaluation Committee. That is the Energy Site Evaluation Committee, not the proposed Solid Waste Site Evaluation Committee. Reason I'm before you today is we're not taking a position either way on this bill, although I will say that in a much earlier iteration of my career, I actually held a level 4 solid waste operator certification here in New Hampshire. And I can tell you that as far back as 2005, perhaps, there was talk of figuring out how to deal with siting of solid waste facilities. So the legislature has been considering this for a very, very long time. But that isn't why I'm here today. The main reason I'm here is because under the current bill, a employee of the PUC would be charged with being the administrator of the Solid Waste Site Evaluation Committee. Since that position is currently vacant, and we're looking for someone who is going to be able to help our very small agency with both energy site evaluation as well as PUC matters, I just ask the committee to consider whether there might not be a better fit in a different state agency for someone who could act in that administrator role. Also keep in mind that when we hire a new administrator eventually for the Energy Site Evaluation Committee, I am probably going to be the person primarily responsible for training that person on how to do their job. I don't have the expertise in solid waste to provide that training to that person. But I think that the type of person we're looking for to fill that role is someone who's an attorney with significant energy and energy siting experience, as opposed to someone that has relevant solid waste experience. Maybe I'm too concerned about this, but it's just seems kind of odd to me to take one of the employees from the PUC and put them into a role that's really a more of a DES kind of oriented agency. With that, I'm available for any questions.
Questions from the committee?
Very
Seeing none,
good.
Thank you
Thank
very much. Amy? Is it Manzelli?
Yep.
Oh, good job.
Good morning, Chair Avard, esteemed members. My name is Amy Manzelli. I'm an attorney at BCM Environmental and Land Law, and I'm here with North Country Alliance for Balanced Change, from whom you heard Tom Tower, I think at the top of the hearing. Just a couple of brief remarks about the Solid Waste Site Evaluation Committee this morning. Of course, North Country Alliance for Balanced Change strongly supports this bill. We do think that it is one step towards solving the issue of how to site expansions of and new solid waste facilities in New Hampshire. And that's because it's sensible and it borrows from the extremely well-established process for siting energy facilities. The large-scale energy generation and energy moving siting facilities. So that process from RSA 162H has been on the books for decades, has been used in lots of projects, and I wanted to share some of the very important key attributes of how that process works that the solid waste industry can benefit from. So one of the biggest ones is that, and Attorney Needleman spoke to this in your last hearing on the totally different topic, but the SEC process at Energy and what would be at solid waste, he said something about applicants have to prepare reports that aren't required for other permitting. And that's true because the SEC process captures known adverse impacts that aren't otherwise permitted. That's the primary benefit of the process. But the other thing it does is it provides a one-stop shopping that doesn't make the overall project permitting longer. It makes it more efficient. And so I'll give you an example from this bill. It authorizes state agency applications and public hearings to be heard concurrently. So you're not going to go file your wetlands application at DES and, have your public hearing at DES and then go file your site evaluation committee application and have your hearing at the site evaluation committee. They can be concurrent. So it's not doubling all of the work. By the way, you can layer up on that. Your alteration of terrain state application, your shoreland state application, your wetland state application, that can all become the one-stop shopping through the central hub of the Site Evaluation Committee. And it is prescribed with certainty through the rules that are developed under the Solid Waste Site Evaluation Committee. So everybody knows what the rules of the game are. The process becomes much more efficient than doing this permit and this permit and this permit and this permit. And it really, really assists with the siting project of what are some of the largest projects that our state encounters. Happy to take any questions.
Thank you, and thank you for your testimony. So you just heard recently from the PUC that although they didn't take a position, it sounded like they took a very sanguine position, if you will, in his tone, that they're not really equipped to take part in this bill Can you comment on that?
Sure. I hadn't considered that aspect of the bill prior to hearing the interim chairman's testimony. So I'm a little bit shooting from the cuff here, but I do think I agree that this is a more Department of Environmental Services oriented proposal because, of course, the Department of Environmental Services processes the primary solid waste facility siting permit, which is the solid waste permit, as opposed to the existing energy site evaluation committee, which hears, energy generation and energy transmission projects. And that is more aligned with the Public Utilities Commission, now also aligned with the Department of Energy, which didn't exist when the Energy Site Evaluation Committee was established. So I'm understanding and empathetic with the point. I'm guessing, but I'm speculating, that the sponsor was thinking, since this process borrows so much from the existing Energy Siting Evaluation Committee, that it would make sense that that one person would be administering both programs. I'm guessing that's why the sponsor did that. But I would imagine the sponsor would be amenable to a change like that.
Senator Waters. Senator Rosenwald.
Thank you. I'm so good at energy now, you'd think I may.
Really good. You read the fine line. We appreciate that.
I'm looking at the makeup of the commission, and I see that there's, a couple questions. One, there's a possibility to have 2 members of the waste management industry on this committee, if the governor so chooses, out of, I think, 7. But I'm specifically also interested in, there's a possibility that someone with business management experience could be one of the members. And I wonder if someone who runs an advertising agency, for example, would actually be a useful member, or if that 7th position that's business management, if there might be somebody better for this, perhaps someone who has a science background.
Yeah, I can comment on this a couple different ways. One is my experience with the evolution of RSA 162H, the Energy Siting Evaluation Committee, and how that has changed over many years because the composition of that committee has changed over the years. And 2 of the major changes have been, 1, to add members of the public, just plain vanilla members of the public, not representing the environment, the energy industry, just regular old people. Not even that, just members of the public. And I think that was an improvement to the process. The second thing was to make it smaller. And that was just a matter of reality. In modern times, it is very difficult to convene a quorum of anything. And so the point is, whatever is enacted in this law, I bet you it will change over time. But yes, I could look at this and tell you, I do see that it could be differently comprised. Perhaps it is a little overweighted by interests in the solid waste community, but I could imagine that if I were the sponsor, I would want the solid waste community to feel comfortable and buy into this bill. And that might be why I write it that way. I think, yes, business and economic affairs, I think that's important to have represented here. But this committee considers issues like this all of the time. And if the committee wants to amend this composition to have more scientific representation, more public representation, I think that would bring more balance, more information, and perhaps be fairer. Yep.
Any further questions? Seeing none, thank you very much. Amy.
Thank you all.
Mr. Wimsatt.
Good morning, Mr. Chairman and members of the committee. For the record, my name is Mike Wimsatt, Service Director of the Waste Management Division for New Hampshire DES. I'm joined this morning by Leah McKenna, who is our administrator of our Solid Waste Management Bureau. I don't have a letter of testimony, but I am here to, first of all, thank you for the opportunity to testify on this bill and to let you know that the department does support this bill. We're certainly aware that, as you've heard from others, that siting, construction, and operation of a major solid waste facility can have impacts on the local and regional communities where they reside. Beyond the traditional factors that DES is required to consider when processing applications for such facilities. Senate Bill 536 would establish this site evaluation committee that would be directed to consider these other potential impacts and benefits that are really outside of DES's permitting process. Areas of consideration include impacts on land use, visual impacts, property values, human health, tourism, outdoor recreation and wildlife, traffic, noise and odor, and economic impacts and benefits. These are all important factors to consider when you're talking about a facility of the size that's envisioned in this bill. But they're generally outside the areas of expertise and authority that DES and its staff have. So we believe that this will provide an important platform for full public participation in siting and approval of these facilities, and will allow for a more comprehensive evaluation of both impacts and benefits. And with that, we'll be happy to entertain any questions.
Thank you. Questions from the committee? All right, I have one. I know that Nashua is going to, is having some changes, I believe, with their landfill. And I believe they want to move their firefighters training to a different location because PFAS situation, closer to the neighborhoods. Are you involved with that as far as the decision-making on, or the site evaluation on that?
Anything that involves regulated areas of the landfill would be potentially subject to, a facility like Nashua would need to get potentially a permit modification to deal with something like that.
So from what I understand, they've hired an outside source to do the site evaluation. They have to go to you as well, as I would imagine.
Yeah, I guess I'm not entirely sure what.
Well, from what I understand, they're getting an outside organization, not the department, to cite the property, but you haven't been notified of this yet?
I don't know, Lee, if you're,
I'm not aware.
I think I've heard something about, my understanding was that the future expansion of the landfill is envisioned, and it has to be said, my understanding is Nashua has significant potential future capacity. First of all, they only take Nashua's waste, so they're not landfilling, they don't landfill the kinds of tonnage that would, and because they're a municipality, they wouldn't be subject to this. But my understanding is that they do have future expansion plans that would include an area that was previously occupied by a fire training site that does have PFAS contamination. So they'll need to address that as part of any future design or construction of expanded landfill facilities.
Does this bill affect their modifications if they choose to?
I don't believe it does. No.
Any further questions? Seeing none, thank you very much.
Thank you.
And I think you are our final speaker, unless the CLF wants to come up and talk. Okay, thank you very much. All right, so we're going to close the hearing on this. Great. Meaning. I'm probably going to introduce this and just.
This one's yours. Yeah.
What's that?
Go for it.
Yeah.
All right, we're going to open the hearing on Senate Bill 593 and recognize Senator Avard, the prime sponsor.
Thank you, Mr. Chairman. For the record, I'm Senator Avard, District 12, and I am the prime sponsor of SB 593. SB 593 strengthens New Hampshire's waste system, prioritizing the cost-effective effective capacity. The bill recognizes the compelling state interest in maintaining adequate, reasonable price disposal capacity for all municipalities and businesses statewide. Without predictability, expansion pathways, New Hampshire risks higher disposal costs and increased out-of-state hauling burdens, ultimately borne by the employers, local governments, and the consumers. Expansion of existing landfills is the most efficient and environmentally responsible path. SB 593 affirms that the state preference for expanding existing permitted landfills instead of creating new greenfield sites because existing sites have already been thoroughly studied, permitted, and monitored by the Department of Environmental Services over decades. This reduces environmental disturbance, avoids opening new sites, and leverages substantial prior investment. This bill promotes landfill expansions at existing sites. It does include some other restrictions for landfills, not expansions, related to the groundwater flow, and it has a 5-year travel time requirement and evaluation of benefits, impacts, including land use, visual impacts, an asset for any residential property within 1 mile of radius, regional economic impacts, infrastructure, noise, odor, and traffic. This bill allows for proposed mitigation to negative impacts. And with that, I'll take any questions.
Thank you for your testimony. Any questions from the committee? Senator Waters, excuse me.
Thank you, Mr. Chairman, and thank you, Senator. So on the first page, line 28, a parcel or adjacent parcels.
I'm sorry, first page, line what? 28?
On 28, where, existing landfill on a parcel or adjacent parcels, including those separated by right of way. Would you, I guess what I'm trying to clarify is this so the development would occur on continuously adjacent, meaning that I just was imagining, let's say you bought a kind of a long and winding series of parcels. You wouldn't be then saying you could have the new site on the farthest one away. That the adjacency here is determinative in terms of every parcel. You see what I'm trying to get at?
Yeah, I do. I actually don't know how to answer that, to be honest with you. But I do believe that it is basically an expansion of an existing site. If you have a parcel not separated by distance, like a winding road, it has to be connected basically to the existing site. That's my understanding.
Yeah, if I could follow up.
Sure.
And I think there's something to discuss, but see what I'm just trying to get at in the public record here is that, let's say somebody bought, a series of 10 acres, 20 acres, 100 acres, which were in a continuous line, and then the place they wanted to put the landfill was on the one that might actually be half mile or a mile away from the existing operation.
Take that into consideration. I don't know how to answer that, to be honest with you.
Just wanted to get it out there.
Yeah.
Thank you, Mr. Chairman.
Further questions from the committee? Seeing none, thank you.
Thank you.
Wayne Morrison?
It's okay with the committee. One of the points I'm going to be talking about is a legal point, and I have an attorney that is also going to speak if you would
You want
mind.
to come up together? Sure, come in. Got it. So we'll bring Amy Manzelli as well first. Okay. Go ahead.
That's what is existing. You've got adjacent parcels. Adjacent to the other. This is the one.
Yeah.
There's a way to deal with it.
Yeah. Chairman Avard, members of the committee, for the record, my name is Wayne Morrison, and I'm here today speaking on behalf of North Country Alliance for Balanced Change. I'd like to preface my remarks by acknowledging the obvious, and that is that the issues we're discussing have been contentious and in some cases highly contentious over the last several years. Despite those challenges, I would, on behalf of NCABC, encourage the committee to seek common ground and make this the year that we find solutions during this legislative cycle. I think there's been a lot of good ideas brought. There's multiple bills. And I'm hoping that with hard work from your colleagues in the Senate as well as the House, that we can achieve much needed results moving forward and make progress this year. That said, while we appreciate and recognize the desire to address these issues with a variety of things in the solid waste arena, this particular bill for us has some serious problems. Chief among those is the paragraph that says to implement the state's preference for landfill expansions over greenfield siting of new landfill capacity, landfill expansions shall be subject to the approval solely by the department, and no municipal ordinances, bylaw, rule, regulation, agreement, or other restriction shall be effective to prevent the siting of a landfill expansion approved by the department. Although we agree and we strongly support the principle of the state preferring landfill expansions and brownfields over new greenfield sites, the data simply does not support the premise that local land use regulations will create capacity shortages, thus frustrating the state's interests. This provision, by design or by default, specifically targets the town of Bethlehem by attempting to negate zoning ordinances and 2011 and 2018 settlement agreements, which were negotiated in good faith and at significant taxpayer expense between the town and NCES/Casella. In effect, this legislation would force a landfill expansion against the will of the town and existing legal contracts that specifically prevent that outcome. We believe such action is unwarranted, unnecessary, sets a bad precedent statewide, creates dysfunction and mistrust between the state, municipalities, and regulated industries, and is likely a violation of both the U.S. and New Hampshire constitutions. There is much work to be done on solid waste reform. Let us work together with communities rather than in opposition to them if we are to make meaningful progress. We are optimistic in seeing some changes and progress and agreements in some of the bills that we are seeing. But usurping local control, in our opinion, is an incredibly bad idea. It goes against, in my opinion, some core values of what it is to live in New Hampshire in a democratic society. And we believe that the answer to some of our landfill and siting problems is found in more local voice, more local control, more regional engagement, not less. For these reasons, we urge the committee to vote ITL on this bill. And with that, I'd like to turn it over to Amy Manzelli to talk about the constitutionality issue I raised.
With the chair's pleasure, I will elaborate and then we'll take questions. So Amy Manzelli from BCM Environmental and Land Law, here to elaborate on our position that this law, if enacted, would be unconstitutional. And I should add that my written testimony for this bill and for 536, I did submit to the committee last night over email, so you have that digitally as well. So Wayne zeroed right in. The particular language of concern is the use of the word agreement in the bill. In other words, that any municipal agreement would be void by the bill. Both the United States Constitution and the New Hampshire Constitution have what is, in passing called a contracts clause. And it doesn't, those constitutional protections don't simply mean that, the state cannot impair contracts. It is not quite that black and white. The states cannot substantially impair an existing contract unless the state legitimately exercises its police power for an important public purpose, and it is reasonable and necessary to do so to serve that public purpose. So I get into the full analysis in the letter, but to get down to where this law falls down, it's the reasonable and necessary part. And it's because there is no disposal crisis. There's no solid waste disposal crisis. There's no compelling need, as stated in the sort of preamble to the bill, based on the state's own data and other stuff like, state policies for the hierarchy of waste and all those things, as I elaborate in my letter. So without having data to show a reasonable and necessary need to substantially impair an existing contract, this bill, if enacted, would be unconstitutional in our position. And I identify what it is that 2011 settlement agreement says. And it's a settlement agreement between NCES and Bethlehem. But it does say right in the settlement agreement that it's between its affiliates, its successors, and assigns to NCES. So that would include Casella. And I'll just mention one of the things. NCES shall not expand the landfill or develop or operate any other landfill capacity within the town's boundaries or outside of District 5. So if enacted, this bill would substantially impair that, because that whole provision would be eviscerated. So, and I wanted to know too, when I was listening to Director Wimsatt's testimony, there's available capacity all up and down the state. He mentioned that Nashua has increasing amount, or has capacity left to go. And that's what the state's data shows, that there is capacity. So accordingly, our position is that this law would likely be unconstitutional if enacted. And we welcome questions. Thank you for your time and attention.
Senator Waters.
Yeah, thank you. Is there a time period related to the 2018 settlement agreement?
So the 2018 settlement agreement, just to identify what that does, it largely ratifies the 2011 settlement agreement. I do not know off the top of my head, but I have that settlement agreement, and I don't want to take the committee's time to read through it right now, but I will follow up over email.
Thank you. I don't know why I had heard that maybe there was a termination date to that.
Right. I'm sorry, could you repeat your comment?
I thought I had heard somewhere there was a termination date to that, but there's not.
No, I'm saying to you, I don't know as I sit here today, but I have the agreement, so I can figure it out.
Thank you.
Other questions? Seeing none, thank you very much.
Senator Avard, could I make one more comment? You raised an interesting point about capacity and the time it takes for a new landfill or expansion to come online. And part of your answer, I think, is in the previous biennial report, right? That 2037 date.
I'm sorry. I'm sorry for interrupting. Go ahead. I'm listening.
That 20, do you understand where the 2037 date comes from? That assumes that Waste Management's facility in Rochester will shut down with no expansion. That's the largest landfill in the state. It does, 1.2 million tons or something a year. That company at previous hearings, their representatives, their vice president of public relations stood up and said, we have every intention of expanding. When it does, that number, that date of when we might need more expansion is not 2037, it's like 2057. There's the large landfills that really matter to our conversation about making sure New Hampshire stays well ahead of any capacity shortage. They all have additional capacity. And there's this restriction in this bill really only affects Bethlehem, which is a landfill that's scheduled to close. And that capacity could easily be absorbed in those other sites with plenty of capacity ahead. Somehow or other, this bill has made a leap from when the governor first introduced her thought about a site evaluation committee. It was all about finding a voice and giving local communities and regions more input to something that they're going to be greatly impacted from. It was not about capacity. It was not about cost. And my final thought would be driving more, I would call excess capacity into the system does not lower price. What it does is it encourages private operators to bring more external out-of-state trash into New Hampshire.
But on that point, if I understand correctly, that Waste Management takes in about 70% of their waste from out of state versus the competitor, which does 40 to almost 50%, which, we're under, we have a constitutional thing going on there with that, right? So if this should die, then the reconsideration for Dalton goes back into play. Is that correct?
We're fine with that.
Yeah.
We don't believe, we fought Dalton because it's the wrong site, a bunch of reasons. We don't believe we need a landfill in either location.
Mm-hmm.
And we think the one is poorly sited and totally unneeded. And the other one, there's an agreement in place that was done in good faith by the town and the company, and we should honor that agreement. And this bill, to me, we can have everything that we want out of that bill without having to force this, us versus them, the state versus local communities. It's just not needed, and it's not productive.
And so on your point, you actually convinced me that the bill's good, to be honest with you. So with a compelling interest, I'm still looking at the idea. Now we're having a conversation. I'm still looking at the idea that how long it takes to get something done in this state. And we've been talking almost a decade on just this particular issue. Maybe more. And we have the NIMBY effect everywhere that we look. And so that being said, if this doesn't go forward, I can see that it would encourage all kinds of resistance everywhere else around the state. And that hinders us from getting rid of our trash and recycling and PFAS. And I wasn't aware of the PFAS situation in Nashua until yesterday when Alderwoman called me up and said, we got a problem. Mm-hmm. And they were going to move the facility, and now they have to do remediation. Mm-hmm. So it's not hunky-dory down there right now because they're going to have to do remediation. We have a lot of other issues, even in Nashua, where they're building new housing over what used to be a tannery. Well, they didn't clean the site up. That's bothering me. But they're going to build on top of that. I have a problem with that. That being said, if we don't go forward with a compelling interest, which I think this is, personally, it's my humble opinion, what do we do?
Going back to 536, that's what we do. And I will tell you just a very quick story about the wind turbines that probably many of us have seen now spinning in Antrim. So that project went through the site evaluation committee, the existing energy site evaluation committee, and it was denied. And it was denied, and I'm not going to remember the details, but it had something like 1 or 2 or 3 wind turbines right up against one of the most pristine water bodies in the state. And that was the primary reason. All of the impacts associated with that. The developers took that to heart. They came back again. They had those 1 or 2 or 3 turbines taken out of the project. The project was approved. That entire thing took the whole permitting that ended in the denial, the whole re-permitting that ended in the approval, took something on the magnitude of 3, maybe 4 years. And my point is, when you have a pretty well-designed and cited project, that's how long you can expect it to take, a couple years through the site evaluation committee. And the other thing we haven't talked about yet is when you have a project going through the site evaluation committee, what that project doesn't do is also go to the local planning board. And so it is a tremendous, tremendous efficiency and benefit for those developers. And so I tell my husband, we're all entitled to have our own wrong opinions. But my opinion is that that is the solution. That is going to hasten getting needed projects and expansions approved.
But as I'm having this conversation with you, it seems to me that history has shown that is just the exact opposite. That to get something done in this state is very difficult. You know, we had a hearing just a little while ago about Seabrook and about the overrunning costs because of the protests. It was a huge part of it. It was unnecessary. There was a lot of fear that was put up with that, and it served none of us because of that. So what I'm saying is if this goes through, who'd want to even dare attempt build anything in this state, knowing our history?
Well, you had testimony at a previous hearing from Waste Management who said they love working in the state. They're prepared to move forward with the turnkey facility. And also, just as a frame of reference, the state of New Hampshire generates about a little over 1 million tons of trash every year. That landfill has the capability of taking every single ton of New Hampshire trash every year.
I'm sure Rochester's happy about that.
Well, I mean, you raised a really good point. Rather than this usurping of local control, to me, the problem that the public and the legislature needs to deal with is the out-of-state waste problem. Yes, we have a interstate commerce clause, but there's things we can do about it. There's other options. We don't have to sit back and say, end of game, there's nothing we can do. We're just going to let this happen.
Question?
Thank you both for coming in. You've both done a lot of work on this issue. I've talked with both of you many times about this as well as other issues. All of these bills that we're hearing, as well as ones we've heard in the past, they're sort of all trying to steer us in the direction of getting a good solid waste management plan. I mean, I think we all are generally in favor of the site evaluation committee being established. We have to figure out what it looks like and the membership and how we get there. I think everybody in the room is supportive of that. The one point, I guess Wayne, I think you mentioned something about, we didn't need increased capacity. We have capacity essentially until 2056. Are you concerned with bringing us down to essentially one major player in the game? I don't know that I can agree with the statement you made that it isn't about keeping costs contained. I think we see in every situation where if we have more than one person competing for the same business, we see lower prices. I think that's a general thing that we would all prescribe to. I guess, are you concerned about that? If we allow things to go as they're looking like they're going right now, we're essentially going to get down to one major player. And additionally, I'll throw in, you can comment on that, a change we made in the budget about the fee we've put on trash coming in and refunding, those back to the communities. That appears to be having some impact, from my understanding, that Waste Management or the Rochester facility is starting to see a little less interest in bringing waste in from other areas into their facility. So that may further extend our ability to have that capacity. So just a couple points, if you want to comment on those, I'd appreciate it.
Yeah, I mean,
Doesn't have to be just you, Wayne. Amy, you can too.
I mean, from my point, it's something we have thought about, right? In some way, this industry is regulated in part because this isn't like a restaurant opening up and there's 100 different restaurants. And if you don't like the prices here, you go down the street. Whether we have one or two of these players, they each have carved out a niche in the state, and they control things like tipping fees, and they integrate, vertically integrate into trucking, and there's a lot of revenue sources that come out of this. I'm more driven by what I want is competent, ethical, well-run, strong operational companies that handle. We're hiring basically companies to handle, a utility. It's not a lot different than energy, right? There's not 50 of these players, right? And I'm no more than you. I'm not looking for more regulation. I don't think we're great at it. But this is an industry that the more we learn, the more dangerous we find out it is. This leachate problem is not going away. The PFAS problem is not going away. It's a burden on our waste treatment facility plants. There's all kinds of issues. I think in an honest conversation, I don't think whether we're already heavily dependent on Waste Management. The fact that we have two of them, Waste Management dwarfs every other facility in the state. They're 3 times bigger, 4 times bigger than what Casella is right now. If they want to jack up prices, they could do it whatever we do, that could happen. But I'm more concerned with the fact that we just saw the largest fine in the history of the state to an operator that has proven over a long period of time to have severe operational issues and problems, and to have not a one-off, but a history of violations. Why in the world would we turn around and create an opportunity to help them expand in a facility when they've proven incapable of meeting our standards? It would be like you hiring an electrician or a plumber or a carpenter in your house and the job isn't well, you wouldn't rehire them. I think we should, I take my stuff, I don't have trash pickup. I take it to my center in town. We load up our truck every week. I think it's really important. We each own this. We are not fighting with you, Senator Ivar. We're trying to be part of a solution here. We've tried to be, we're not here to beat you up. It's a difficult problem. We want to be part of the solution. We keep bringing different things to the table. Our experience just says, this bill, I agree with some of it, but this taking away local control is going in the wrong direction at way too fast a pace, and it won't solve the cost problem that you're bringing up.
On that local control.
May I just
topic-
comment real quick?
Sure.
Thank you. Real quick, completely different point. I think in terms of markets and capitalism, it's important to remember the potential to monetize parts of the waste stream that is not yet monetized at an industrial scale today, which is composting. The lawmakers very wisely took a first step towards this a couple of years ago by requiring certain institutions to take their food waste and not put it in the trash. I think the monetization of composting is going to be a huge opportunity in the future. And I don't know if Waste Management is going to jump on it or some other entrepreneur is going to jump on it, but if and when waste disposal becomes too expensive, that's going to be a natural market reaction. And so I just wanted to throw that out there. Sorry to interrupt.
No, that's fine.
Can I actually respond to that real quick, if you don't mind?
I don't mind.
All right, so we actually, in the bill we had in a previous session that hasn't not been finished on, there was a section that was further encouraging companies to come in to do food waste. Unfortunately, to sort of affirm Senator Avar's earlier point, we've dragged our feet on this, and they've now decided they're going elsewhere.
Yeah.
So we've lost an opportunity there that
Huge
that
opportunity.
would have been quite a processing facility to have in the state of New Hampshire. So we do need to get this done. And I know there's further conversations that are going to continue to go on, and I appreciate all that you're bringing to the table, the ideas, whether I agree or not, it makes, that's not the point. I appreciate the ideas coming forward, and it's really helping us to shape what I think is going to end up being a good policy in the end. So thank you for that.
I wanted to, I'll get you in one second, but I did want to reiterate what Senator Pearl had said, that we had conversations with other companies that wanted to come in and set up the food waste, recycling and whatnot. And they politely just bowed out. And I do believe it's because of what's going on. And I think it's sending a signal to, across the board. And so, we're a big legislature. If we can agree on something, it's huge. But getting there is very difficult. But we need to start doing it. Senator Rosenwald.
Thank you, Mr. Chairman. And I'm going to give a shout out to Nashua, which has a local composting business. I don't participate in it, but my niece does. And
I do that in my backyard, actually.
she's really into it. But I want to follow up on Senator Pearl's reasonable fear of creating monopolies. And I'm thinking that there's also a landfill up in Berlin. So we're really not talking about just 2 sites, are we? We have 3
We have,
plus Nashua.
we have 6 landfills and an incineration facility. I mean, the point around, we're all worried about cost and we're worried about service and all the rest of those things. The closest thing we have to a solid waste strategy is our solid waste management plan, right? That clearly articulates the goals that we really want are to move away from landfilling and move into diversion activities.
Right.
And we don't, we should be in, the infrastructure we need is in recycling and composting and all of those things that will actually help us put less stuff into the ground and put our citizens at less risk.
But it was my understanding that if the company that you had mentioned came in, they would be building a $100 million recycling plant. But, in addition to that,
They could do that anyway, though. They don't need a landfill to do that. They could do that at any time.
well, we had a study on this landfill issue. And one of the things that was very compelling about the study, obviously we had the interstate compact thing, whatever, and all that. Very interesting. But we heard that incineration reduces tonnage by 2/3. Try to get that built in New Hampshire. Come on. It's not working. We're having everybody say no, no, no. I know there's one in Bosquen, but this is what I'm seeing over and over and over again, where there's always opposition and it shuts things down. And I do believe there's a fear factor which is unwarranted. And I'm going to say it out loud: slander. I've heard slanderous things come out, just because we're trying to propose an idea. And not you.
I'm a lawyer here.
But
We try really hard to prevent that.
Can I just say that really shuts everything down?
It's not our style.
I know it's not your style, but there are people out there that have been slandering, not just me, but other people in the committee. And that always puts my hackles up, and it just pushes the wrong button on me. That's why we're having a conversation right now.
May I make a comment to that?
Yeah.
So this goes to what you just said as well as what you had said previously. One of the primary benefits of a site evaluation committee, which I am very happy to hear comments like most folks are in support of that, is the certainty of process and standards that it provides. Because in a future where it would be enacted and then the rules are promulgated and passed, developers that may be looking at the status quo now and saying, no, thank you, might be looking at that future status quo and saying, yes, I want that. I know what the rules of the game are going to be. And in that future status quo, you're not in the position of trying to say incineration is the solution. Biosolids are the solution. This is the solution. You've set up the method, the structure, and then developers can put forward their idea and the structure can take it from there.
All right, we've had a nice conversation,
Thank you.
and I have to move it along because we still have other people, but thank you for your
Thank you.
testimony.
Likewise.
Nate, did you want to speak?
Yes, please. Thank you, Mr. Chair. H. Grace for the BIA again. We support this legislation. One of the things you hear from us quite a lot is that we always like streamlining governmental processes. So when there are two governments regulating one thing, we always urge the legislature to pick one. Generally works better because then we don't have the possibility of conflicts in regulations and makes things a little bit smoother. The other thing that we appreciate about this bill is it deals with some of the issues that keep coming up over the years, like this groundwater setback issue. There's now a set and workable solution here for a 5-year time horizon rather than what has been previously proposed. It also avoids some of the issues in other legislation pending before this committee, such as the PUC issue and whether they should be involved. And I'm not sure I have a whole lot additional to add to this, other than to say it seems very clear that this legislation prioritizes expansions over new landfills, but does put in place some additional considerations for new landfills, including that groundwater portion, which all seemed quite reasonable. The last point I will make before taking questions is on this constitutional issue. I'm not really very prepared to speak about that, but in evaluating a claim of any sort of litigation, it's important to keep in mind who has standing to make the case. In this case, it would appear it would be a private company, and then on the other side of things, a subdivision of the state, a municipality. There are plenty of examples within state law where the state has stepped in loco parentis, standing in the place of the parent to say, hey, this is an important issue. We're taking over from the local jurisdiction. I'm not sure why this would be very different. Again, I'm not prepared to make any sort of legal argument here, but I certainly think there is a justiciable question as to whether or not that claim would even rise to standing.
Thank you, Nate.
Happy to take
Questions from the committee? Seeing none. Appreciate it.
Thank you.
Let's see. I guess that's Rue. R-I-E-W. Rich? Rich. Sorry, Rich. I got dyslexia, so I can say that anything I want.
My penmanship is lacking.
I remembered you from the last one.
You've heard a lot of discussion, and I don't want to limit too much because we do have to go over a couple other bills, but if you can kind of.
I think you need to hear from the town of Bethlehem on this one.
Yeah.
So I oppose this bill because it subverts local control and represents an enormous gift to Casella Waste Systems. That is the same company that recently agreed to a $1.9 million settlement. I want to make sure I read the exact right word so I don't get sued. Over alleged violations related to leachate management and leachate data and reporting in Bethlehem, New Hampshire. If this bill becomes law, here's what happens. The state of New Hampshire will attempt to void a lawful contract entered into between the town of Bethlehem and Casella. A key element of that settlement in 2011 between the parties was there would be no further expansion once their permitted capacity had been reached. As it turns out, in its 2024 annual 10K report, Casella expected to reach its permitted capacity at NCES in 2027, and so this is arriving just in time for them. This bill is being proposed just in time for them to escape from a contract that they desperately want out of. They have been trying to get back into that town ever since they signed it. The taxpayers of Bethlehem spent $1.3 million, taxpayer dollars, through approved warrant articles and budgets to secure that agreement. There is no mention of compensation for those costs if the state decides that it wants to try and void that contract. Bethlehem will lose its ability to negotiate compensation for tipping fees because this bill includes a very easy to manipulate $2.50 floor per ton on tipping fees. That's services and cash combined. Who controls that? Casella does. They have the data. Bethlehem will be forced by the state to accept expansion of the NCES facility and assume all risks and negative impacts that come from having an operating landfill in the community, including pollution, contamination, odors, and decline in property values. Now, we talked about some of the risk factors in my previous testimony and the extreme risk and the increasing risk that that facility provides. And we will not be protected from any of those potential violations in the future. And if you question that, we can take a look at what happened recently with the $1.9 million settlement. So the violations in question occurred in Bethlehem at the NCES facility. The settlement was for $1.9 million. The alleged violations included puncturing the liner in the landfill. So I'm not a landfill guy, I'm a business guy, but it turns out that that liner is designed to keep the bad stuff in the landfill from reaching the good stuff, clean drinking water, underneath the landfill. They punctured a hole in it according to the alleged violations in there. So the state, the AG's office charged them $1.9 million. Where did that money go? $200,000 of it went to a remediation project elsewhere in the state. The other $1.7 million went directly to the general fund of the state. The town of Bethlehem bore the brunt of it. They got nothing, and they will get nothing. We have an AG. We have a letter from the AG's office saying, well, by statute, it's got to go into the general fund. That's just the way it is. This bill is also a roadmap to end local control in New Hampshire on any issue, because as soon as a locally inconvenient, or as you call it, controversial issue raises, this provides a roadmap. It's a one-page bill. It is very simple to replicate for data centers, crypto mining, the power to run those data centers. And somebody mentioned small modular reactors earlier today. You guys are going to undercut, and sooner or later it'll come to one of your districts. But you've provided a roadmap for short-circuiting local control, and that is wrong. Given the negative, one-sided nature of this bill for Bethlehem and its potential to subvert local control statewide, I urge the committee to spike this bill and start over with a fresh sheet of paper. Thank you.
Questions from the committee? Seeing none. Thank you very much for your testimony. And our final speaker, Heidi, CLF. I'm surprised he didn't sign up. Whatever you want. Sure.
Good morning, Heidi Tremarco from the Conservation Law Foundation. I know we've had a vibrant discussion, so I'll try to keep my comments short because a lot of it overlaps with things that the committee already discussed today. Thank you to the chair and the members of the committee for hearing my testimony. In short, CLF opposes this bill because it removes local control and the local voice from the landfill permitting process. As everybody knows, the state already controls the lion's share of that process, and the local entities have only carved out a really small voice in that process, really thanks to Bethlehem's efforts for decades, including a fight to the New Hampshire Supreme Court, which established in 2004 that there could be some local voice in the process, normally over only really where the landfills are located within a municipality. And that voice is small, but it's critically important. You know, the communities that are asked to home these landfills should have a voice in that process, and they know best. And often these decisions come down to really specific things that are very local, like how are the roads going to be impacted? And do children walk to school along those roads? It's the local groups and the towns that know that information best. And I just want to speak briefly to, the bill presumes that there's been a frustration of the state's waste needs, and specifically, I think there's a concern that their landfills have not been able to expand or that it might take some time. And I think actually if we look back on what's happened as the state, is we see landfills expanding again and again. So Bethlehem's currently operating in stage 6, and that landfill expansion process took about 3 years. The public notice was in 2020. It was fully litigated. There was a full public process, and then we litigated it before the Waste Management Council, and then up to the New Hampshire Supreme Court, which allowed the landfill to go forward in 2023. So from 2020 to 2023, there was about as lengthy of a process as you could get for an expansion that was fought at the permitting stage, at the Waste Management Council, and at the New Hampshire Supreme Court, and that took 3 years. And when the Supreme Court decision came out in 2023, they began operations immediately. They had already gone ahead with the construction. And I think turnkey, it was a similar process that was also litigated up through the New Hampshire Supreme Court, and it was a matter of years. So I don't think we should be concerned that they're limiting or it's taking too long to expand the landfills, because that is happening. And it doesn't take very long. It takes a matter of years under the current scheme. And as you've heard, we don't have a capacity problem. We don't have a need for additional landfills. What we need, as what's been acknowledged, is recycling facilities and composting facilities as has been laid out in the state's waste plan and in the biennial reports. So that's the only points that I wanted to make today to address those concerns and to urge the committee to vote ITL. I'm happy to take any questions.
Seeing none, thank you.
Thank you.
Senator Rosenwald would like the department to come up. That's it.
Thank you, Mr. Chair. Thanks. I do have a few questions. I noticed on page 1, line 19 of the bill, that it says the department's rules provide robust protection of human health and the environment. Am I misremembering, or did last fall GELCAR unanimously object to the proposed new rules and state that they were contrary to the public interest, designed to benefit, I'm quoting, designed to benefit the administrative convenience of the agency to the detriment of the public and contrary to legislative intent?
Yes, Senator, they did file a preliminary objection to that effect, and then we responded to that, and at their subsequent meeting, they approved the rule set.
Thank you. Could I? Oops.
Yep.
Thank you. So on page 2, lines 22 and 23 calls for new landfills being sited so that pollution can't reach the nearest surface water for 5 years, which is great, unless there are, quote, design features that will detect and remediate contamination before it reaches the river or lake. Because I'm so inexperienced in these matters, could you please tell us what kind of technology exists, or maybe it doesn't yet but could, that would remediate polluted groundwater?
Well, I'm not sure. I don't know exactly what that provision is intended to mean. I suppose if you look at features on the site, obviously we have robust design and construction requirements for the landfill itself. And then to the extent that those fail and there's a release of a contaminant, then basically the migration, absent any other interventions, the migration of those contaminants through groundwater to a surface water is a function of the hydrogeology of the system. So the soil type, the groundwater table, the groundwater gradients, etc. I suppose if a facility could, I mean, when we have groundwater contamination that needs to be controlled at a site, it is not too uncommon for some kind of an interception trench or a pump and treat system to be installed. One of those is very active, the pump and treat. You're actually pumping groundwater and treating it and then re-injecting it up gradient to keep it from migrating. Or depending on the type of contaminant, there are types of interception trenches that can be constructed in the formation that hold back those contaminants as they move, as the groundwater moves through that trench. I don't know if that's what this is envisioning or not, but those are the kinds of design features that I could think of. I will say that the rule set that is currently in effect, we believe is quite protective and very stringent. And if you look at it in its entirety, if you look at the rules and you look at what we require with respect to siting, we believe that those rules are quite protective. And we don't believe this provision is necessary in this case. We believe the rules that we have are very protective and would address potential threats to surface waters.
One more. So Senator Avard brought up a project in Nashua that's not a landfill, but is a housing development that's going to be built on a toxic Superfund site. And the department's been quite involved in that Mohawk tannery.
That's correct.
And there's a whole plan to build a containment system so that leakage of, I can't even remember what, the tannins, and I think there's some asbestos on the site.
That's correct.
That doesn't happen before it leaks and pollutes the ground and the water. But isn't that project like a multi-million-dollar project that's going to be a lot of federal funds, some state funds, probably some city funds, and also some private developer funds? So to do this before something bad happens, wouldn't it cost just millions of dollars?
You're correct about the Mohawk Tannery site. That's a complex project with a long history of use, decades of use, and a lot of contaminants that were deposited near the river's edge over decades. I want to make sure I understand your question. How are you relating that to
Well,
this?
the question is, if we were to expect that a private company would install some kind of leak-proof system before they expanded or built, wouldn't a good system just be unbelievably expensive?
So it depends on the circumstances. It would be it's hard to answer that. I will tell you the current rules envision that in order to site a landfill, you need to be able to ensure that in the case of and I will say, there's a lot of focus on surface water, but in reality, in the facilities that we have and that exist in the state right now, surface water impacts, we have a lot of surface water impacts from old unlined landfill facilities. That's a separate matter. But from the landfills that are operating, surface water impacts are not something that we are most concerned about in the first instance. We're concerned about the groundwater, which is right there at the facility. These facilities are sited, wherever they're sited, there's groundwater beneath them. So we're mostly interested in ensuring that groundwater is protected. And our current rules require that the landfill be sited and constructed such that if contaminants are released from the landfill, they can be detected, monitored, remediated before reaching the property line, which in most cases, unless you've got a surface water on the property, it's going to be much closer than any surface water that's further away from the site. So that's where I think that's one of the strongest provisions in our rules that help to ensure protection of this. There's also similar language that says that you need to site it and there's a minimum nominal setback, but also you need to site the landfill such that any potential impacts of released contaminants to surface water can also be detected, remediated, and are monitored and remediated before reaching the surface water. Our rules do not envision some kind of pre-installed remedial system outside the landfill. We expect that the landfill as it is, without any remedial systems, will be designed, constructed, operated, and sited such that there will not be an adverse impact on groundwater off of the site or on surface waters.
Senator, we're running on time for exec session, so if you have one more question.
I think I won't.
Okay.
Thank you.
Thank you very much.
You're welcome.
And with that, we're going to close the hearing on 593. Is there a motion to move into exec? So moved. Discussion, all in favor? Any opposed? Seeing none. Senator Waters, do you have a bill that you want to take today?
A couple, actually. You start with 540, and you have an amendment, I'd be glad to discuss it.
540?
Yeah, Senate Bill 540 for the portable solar.
Yep.
So I'll move up pass.
Second. Discussion?
Mr. Chairman, so what we did following the hearing, as I've informed you, is we got everybody together, Sam Evans Brown did, and I had a lot of conversations. And there were basically two areas to look at to create a bill. We wanted to make sure that we had the appropriate safety provisions, and we wanted to make sure we had the appropriate notifications for customers and for utilities. So while a lot of this bill is familiar, you'll see a couple of important changes that everybody has signed off. Good discussion with the Department of Energy, with the utilities, and I really appreciate all their work on this as well as others. So in particular on the code here, that the code board noted that, look, there's a new set of codes coming down, UL 3700.
So you offer an amendment?
Yeah, this is amendment 0450. You got it. I'm talking about the, I'll move the amendment.
Yeah.
Sorry.
Second. Okay, third.
All right, it's been a long morning. So the language that they wanted was to say that they would relatively quickly do what needed to be in code, and that would govern that, rather than listing previous UL standards, which are going to be preempted by UL 3700 and what they do. So that takes care of that. Everybody's good with that. Then the second part of this, which is relevant to all the discussions we've had, is on page 2. And it says 3 there, that the utility, if they raise the issue about how we're going to know over time how many of these are there and what impact that may have on the grid, on our load, and so on and so forth. So that the utilities have different perspectives on this. So it basically says, the utility, the owner operator of portable solar may develop a method for the owner to inform the utility of the wattage number of devices, and that's for notification. And that seems to be a good way to go on that. Then you'll just see that there's a little bit more add in the Institute of Electronics, IEEE, which I had just neglected to put in it previously, but that's an important body that the codes and others will turn to look for their
On line 21.
standards as well, line 21. And then lastly, I think important, because we heard kind of towards the very end from Eversource, so that, by the way, our current meters, let's say that your portable solar device generates more than you're using, and that excess monthly is going out into the grid, guess what? You get charged for that as a transmission. And that could be an unfortunate surprise to consumers. So what this will do is provide information, and that I appreciate the DOE stepping up to say that this would be easy for them to do. That all the issues about it, what they are, the installation, the safety provisions, this is and that's, but also this point that let them know that if you've got one of these and your utility area has these meters, now Unitil has more modern meters, so this doesn't become an issue, but for Eversource, it is. And so this is what they thought would work as well. So sorry to go on so long, but I just think we solved all the problems, and I'm so appreciative of it. And I think we got a good bill.
Further discussion from the committee?
I have a
Senator
question.
Pearl.
Senator, page 2, lines 1 through 3, you're requiring the state building code review board to amend the state building code to address the portable solar generation devices. I'm not sure they can comply with that prior to January 1st of 27. I don't know that they can get through the process.
Thanks for the question. This is what they wanted. They said they could.
Okay, and they're
Yeah,
okay.
yeah, this is their
You talked
language.
with Phil
This is their language.
and
Yeah, he was in part of all these
All
discussions.
right, he can meet that deadline?
This is their language.
Okay.
It says this, and that's why we put the effective date out to
Yep.
give them time to get it done.
All right.
They think
That
3
was-
months.
Okay, that was my concern.
That's why it's there. Thanks for bringing that up.
President Senator Rosenwald.
Thank you. I see that you've increased the maximum power output from 800 watts to 1200.
Thanks, but it's going back and forth. I had 12, I went to 8, and then realized that with the other provisions, 12 was okay.
Is it?
Yeah.
Okay.
That's what everybody said, so that's why it's back, that's why it's in there.
Any further, okay, all in favor of the amendment?
Aye.
Aye.
Any opposed?
Ought to pass as amended.
Second.
Discussion? All in favor of ought to pass as amended on SB 540?
Aye.
Aye?
Aye.
Any opposed? Seeing none.
I'll move consent.
Senator Pearl, consent, Waters
Second.
endorsed it. All in favor?
Aye.
Any opposed? Who would like to take this out? Senator Waters. You said you had another one?
I have 589, if you want to turn to that, colleagues. I'll move ought to pass on Senate Bill 589.
Second, for discussion?
Sure.
And I will introduce amendment 0461S.
I have so many papers up here.
I know.
Me too.
Second for discussion.
Okay, so, thank you, Mr. Chairman and colleagues. This reflects, the hearing, and also I headed the hearing, requested that, DOE and utilities come up with what they wanted on the microgrids and the cybersecurity, and they were happy to do that and have done it. So let me walk through what it does. It got rid of the highway and transportation stuff. It's gone. So, heard that loud and clear. It's out of here. The ports would like to do this. I've talked with the ports director, and with the chair of the Peace Commission. They think this is useful for them, particularly because of what's happening with technologies in the marine industry. That port, that part of it is then down at the bottom there. That is just the port director and a few other folks who will look into the issues around the port. And I will mention on this that just a few days ago, they have entered into an agreement with a private company that wants to start to provide some charging for certain small vessels. So this is particularly timely in letting them look at the bigger picture as well. Then the microgrid issue on page 1. This is what DOE said they wanted, the great work that Tom Barassa and others did with the microgrid study. And so we've got a definition here. And then you'll notice on the next page, microgrid investigation phase 2. This will be session law. And it says, keep the good work going. And here's what emerged from the microgrid investigation report part 1. It included these other items that they wanted to be looked at. Financing options, CPACER, identify those areas where one of these might be useful. a sandbox methodology, which is, a way of dealing with all the regulatory issues that are involved. And then have cybersecurity standards for the microgrids, that they see that as a very important thing to do, and then advise us on whether we need any legislation or regulatory relief to allow for pilot projects, which the original report suggested that was the way they thought that should go. And if there are pilots, what are the criteria for doing that? The last part of the bill that changed is here under cybersecurity and electric grid interconnection guidelines. Again, as I said in the hearing, I was going to ask the department, and because DES Commissioner Scott is heading up the kind of one of the statewide groups in cybersecurity and others, to come up with some language on this, and this is to make sure we have cybersecurity for interconnection of distributed energy resources. This is an important thing to do, as I mentioned in the hearing, because of real security threats we're seeing around chips that are appearing in devices and so on and so forth. In consultation with the governor's advisor for utility, critical infrastructure and cybersecurity, manager of the New England Utility Cybersecurity Integration Collaborative, and talk with the distributed energy resource businesses and regional federal authorities to determine, what do we need to do? How do we do those guidelines or standards, and give us a report on that. The remaining part of the bill from Commissioner Scott on the public water system, just the same. So that's it. I think we've wrapped up everything that people wanted done, and here it is.
Further discussion? Senator Rosenwald.
Thank you. Thank you for this work. Just want to highlight that the DOJ now has a cybersecurity unit, and it's funded on an ongoing basis through the escrow fund. So I'm sure they will love having more work to do, but we've got the resources across the street, or we're down Granite Place.
Okay. Is there a motion to, yeah.
We've got one on the amendment.
So, all in favor of the amendment?
Aye.
Any opposed?
I'll move ought to pass as amended.
Second. Discussion. All in favor of ought to pass as amended?
Aye.
Any opposed?
Consent. Second.
Discussion. All in favor of consent? Any opposed? Seeing none? Don't we love energy? Are you ready for 592? Senator Waters will take that out. Enabling regional conservation and energy planning and habitat stronghold wildlife corridor.
I'll move 592 ought to pass.
Is there a second? Second by Senator Rosenwald.
And I'll be happy to move unless you'd like to.
No,
Mr.
I'd like
Chairman,
you to
your
do it.
amendment.
Thank you.
0469S.
That's Senator Green's amendment. I'll second it.
Do we have that amendment?
Should be. Everybody has this one, right? 0469S.
Oh, there it is. I do.
Everett's Water Lang amendment.
This includes my earlier amendment.
Yeah, mine.
You got it, yeah. If I miss, Mr. Chairman, let me
Absolutely.
speak to the first part of it. I did what people wanted me to do on the conservation commissions and the regional planning. I took to heart what we heard from our colleague Senator McConkey and from the timberland owners. And the timberland owners helped develop this phrase that this inventory of strongholds is intended for informational purposes for regional planning commissions and shall not be utilized as a sole basis for municipal zoning or planning purposes. So I think that deals with the concern that they had raised about this might, people come on your land or they might start zoning, or I heard what happened up in Lebanon around a deer habitat area or so on. And essentially then what it means that the Conservation Commission work in fact, will then connect basically and only to what is done by the Transportation Department. As I mentioned before, on the RPCs already are required in state statute to take a look at these areas in formulating the 10-year plan and other transportation projects. So that here too, you'll see that that language makes it very clear on lines, page 2, lines 33 to 35. Note how the commas and the semicolons are done. That this just references transportation, communication, and other kind of purposes related to the work on transportation communication. It does not get into conservation or expand their regional planning committee purview to look at larger things about habitat. It is just limited to the projects in communication and transportation. So that's that part of it. And I hope that it, I meant to make sure that I addressed every concern that people had.
And Senator Lang's portion of this, was he, I mean.
Yeah, so I'm good. I talked to Senator Lang about this, and I'm good with this. This is something we really need to do with the Winnipesaukee River Basin Program. That, you know, we need to look at this issue, and it's something that's been very important for that region and for Senator Lang. So it's gonna look at what do we do about that river basin, potentially the commission there, figure out transferring ownership. You'll see how this is all laid out, all the things that need to be done by the commission so that they can get some resolution to what's happening with this property. That's what it is.
Senator McConkey, you also with this amendment?
Thank you, Mr. Chairman, and I appreciate Senator Waters taking time to craft. I'm just still mulling over the word sole basis.
On what line?
On line 23.
In the page?
I'm sorry, page 1.
Would you like to cut sole?
My concern with this always was, or is, that the good work being done by this group would then take away rights of the property owner, especially legacy landowners that only have very large tracts of land but may have limited road frontage and so forth. And I apologize because I should have caught this earlier. I didn't see the word sold.
Let's take it out.
Does that make it better for you?
It makes it very much better for me.
So, Joshua, on line 3, yeah, we'll cut that as a committee amendment to the amendment.
So we would just read utilize as the basis, and we're removing the word sole, am I correct?
Yes.
Yeah, okay, all right.
So I think that'll be
So
much clearer, much clearer.
Let's vote on that part just to make it clear. Just the
Yes.
sole on amendment 0469. All in favor of changing that word?
Aye.
Any opposed? Seeing none. Senator Rosenwald, you have a question?
Yeah, thank you. My notes from the hearing say that Mike from Fish and Game was concerned about the requirement that Fish and Game shall consult with regional planning commissions. His concern had to do with
With
the
I missed
federal
it.
funding.
It should be May.
And could we change that to May?
I had
What line,
intended
what page?
to, on,
That is on page 3, line 15.
thanks for catching that. I changed that in the draft we sent to OS. I didn't realize it hadn't happened, so that's my bad.
So line 15, there's another committee amendment to the amendment. Shall
to
strike
May.
shall and turn it to may. So all in favor of changing that language, say aye.
Aye.
Any opposed?
If we don't have any other changes, we can just vote on a committee amendment, incorporate the two of those.
Correct.
Yeah, okay.
Yeah, thank you, Senator Rosenwald. Hopefully.
Any further discussion?
The grammar queen.
I know, I love it. I hated grammar. But is and was is a linking verb.
It doesn't hate you.
Great, just
It's still lucky.
Maybe we could just Change sold SOU well.
Yeah, that's all.
I'm thinking of Dover, so.
Yeah, that's right.
Oh, we gotta get out of here.
Yes.
So, all in favor of the committee amendment as amended?
Aye.
Any opposed? All in favor of the bill as amended?
Aye.
Aye.
Senator Waters.
Senator Waters making a
I'll
motion.
second it.
Senator Waters, seconded by Senator Pearl. All in favor of the bill as amended?
Aye.
Aye.
Any opposed? Seeing none? All in favor of consent?
Aye.
Any opposed? Seeing none?
Does he want the trifecta? He can have all three of them.
Senator Waters, you can take it out again.
Yeah, and if, I'll check with Senator Lanning if he wants to say something on the floor, but of course he can always just vote.
And is there a motion to move out of exec?
Moved.
All in favor of moving out of exec?
Aye.
Aye. Any opposed? Seeing none? Ready to dismiss? All in favor of dismissing?
That's on you.
Let's get out of here.
So,
That's not a vote.
I still.
Yeah, we gotta get out of here
I
though.
know, Michael wants to talk to us.
Michael.
Okay.